The court filed its ruling at 9:47 in the morning. The hearing didn't start until 2:15 that afternoon. The order was already stamped, already entered into the docket, already in the file with the clerk's initials and the date. 6 hours and 28 minutes before anyone walked into that courtroom. Case 14 PB08834, Multnomah County Probate Court, Portland, Oregon, September 22nd, 2014. My signature is on that order. Oregon Bar number 472291. I signed a document that was filed before I ever left my office that morning. And I know what you're thinking. Clerical error, typo, wrong timestamp in the system. I thought the same thing. I spent 18 months trying to prove that. I couldn't. My name is Raymond Caulfield. I practiced estate law in Portland for 26 years. Probate cases, trust disputes, contested wills, the kind of work that is slow and careful and procedural, the kind of work where the paperwork is the point. I retired in 2021 not because I was ready, but because I could no longer trust what I was reading in my own files. This is about one file in particular. The Voss matter came to me in the spring of 2014. Martin Ellery Voss had died in January of that year. 63 years old, retired, no surviving spouse. He left behind a house in the West Hills, a brokerage account worth roughly $400,000, and a handwritten will that two nieces both believed named them as the sole beneficiary. One of them hired me. Her name was Caroline Voss Ardmore. She lived in Bend, drove up to Portland once a month for meetings. Quiet woman, polite, grieving in the way people grieve when they didn't expect to need to grieve yet. The other niece had retained her own attorney. The hearing on September 22nd was supposed to settle the dispute. A probate judge would hear both sides and decide who inherited what. Standard procedure. I had handled 40 cases like it. I prepared the usual way, reviewed the will, assembled the exhibits, confirmed the hearing time. 2:15 p.m. Multnomah County Courthouse, 4th floor. I packed my files that morning, kept my 10 o'clock appointment with another client, had lunch at my desk. Nothing unusual. Nothing wrong. At least, not yet. I didn't find the problem until 6 weeks later. I was closing out the file, preparing the final billing statement for Caroline, tallying hours, cross-checking the docket entries against my own notes. I pulled the court copy of the final order to confirm the entry date for my records. Every document filed with Multnomah County Probate Court gets a stamp in the upper right corner. Date, time, clerk initials. The final order, the one that settled the estate, ruled in Caroline's favor, and closed the case, was stamped September 22nd, 2014, 9:47 a.m. Clerk, T.W. I set the paper down. I looked at it for a moment. Then I pulled up the hearing transcript. The transcript is a word-for-word record of everything that was said in that courtroom. Every argument, every ruling, every motion entered. The cover page reads, In re Estate of Martin Ellery Voss, Case Fort Tash, PB-08834, Multnomah County Circuit Court Probate Division. Date of proceedings September 22nd, 2014. Commencement 2:15 p.m. 2:15 in the afternoon. The ruling was filed at 9:47 in the morning. That's not a transposed digit. That's not a formatting glitch in the docketing system. That's a 6-hour and 28-minute gap between a court order and the hearing that was supposed to create it. I went back through my own records. My calendar for September 22nd showed I arrived at the courthouse at 1:50 p.m., 25 minutes before the hearing started. I have a parking receipt from the Broadway Bridge garage, time-stamped 1:44 p.m. I paid for 3 hours. I was back at my car by 4:30. I was not at the courthouse at 9:47 in the morning. I was not anywhere near the courthouse at 9:47 in the morning. I was at my desk. My assistant confirmed it. She keeps a handwritten log of everyone who comes and goes from our suite. September 22nd, 2014. Client consultation at 10 a.m. Departed 10:55. Phone call with opposing counsel at 11:30. Lasted 30 minutes. Caulfield at lunch from 12:15 to 1:10. Departed for courthouse at 1:25. I did not sign anything that morning except one billing authorization for a different client, but my signature is on a probate order filed at 9:47 a.m. My name, my bar number, my handwriting, on a document I have no memory of producing. I went to the courthouse. I asked to speak with the clerk of courts, Dennis Hargrove. I had worked with Dennis for over a decade. Reliable, careful, the kind of clerk who catches other people's mistakes before they become problems. I explained the discrepancy. He pulled the file. He reviewed the docket entry log. He looked up at me and said, "The 9:47 a.m. entry is the only entry. There is no amended filing. There is no duplicate. This document was received once at 9:47 a.m. on September 22nd. I asked if the hearing had been moved, originally scheduled for the morning perhaps and then pushed to the afternoon. He checked the case calendar. The hearing was always set for 2:15 p.m. It had never been rescheduled. I asked if there had been any morning session, a status conference, a preliminary motion, a judge's chambers meeting, anything that might explain an early court appearance by either party. Nothing. No morning hearing, no conference call, no informal proceeding of any kind. Nothing until 2:15. The only proceeding that day was at 2:15 p.m. The order was filed at 9:47 a.m. I took my copy of the file and walked out into the rain. That night I read the order again, all 4 pages. And that's when I found the second problem. This is not a form order. It's not a template where someone fills in names and rulings and prints. This order is substantive. It contains specific language from the hearing. On page 2, it references a particular clause in Martin Voss's will, paragraph 7b, and includes the judge's finding that the language in that paragraph reflects testamentary intent inconsistent with an equal division of assets. I remember making that argument. I stood up at 2:15 p.m. and I cited paragraph 7b specifically. I used almost exactly that phrasing. The opposing attorney objected. The judge ruled from the bench. It's in the transcript, page 31, line 14, word for word, and it's in the order filed 6 hours before I opened my mouth. I've been practicing law for 26 years. I know what advance orders look like. Sometimes attorneys draft proposed orders before a hearing, anticipating a ruling they expect. It's common, it's legal, it saves time, but there are rules. A proposed order is a draft. It is not filed. It does not get the clerk's stamp. It does not enter the docket. A proposed order becomes a final order after the hearing, after the judge signs it, after it goes through the clerk's office in the normal way. What I'm holding is a final order. The judge's signature is on it. The clerk's stamp is on it. It is in the docket as Case 4 PB-08834's operative judgment, and it contains arguments from a hearing that hadn't taken place yet. I checked my signature carefully. I've signed my name on 10,000 documents over the course of my career. I know what my signature looks like when I'm tired. I know what it looks like when I'm hurrying. This one is clean, deliberate, the version I use when I want to be careful. It's mine. I know my own handwriting. I just don't know when I produced it. I don't know where I was. I don't know who handed me that document. But somewhere, in a moment I cannot account for, I signed a court order that shouldn't have existed yet. And then it was filed 6.5 hours before the hearing it recorded. And I walked into that courtroom at 2:15 in the afternoon and made the exact arguments that were already written down, already stamped, already official. The Voss estate closed without any trouble. Caroline Voss Ardmore received the house and the account. She thanked me. She sent a handwritten note. I filed everything properly, I billed accordingly, and then 6 weeks later I sat at my desk and stared at a timestamp that couldn't be right. That was the beginning. I wish I had stopped there. The first thing I did was rule out the obvious. I called the court's case management office and asked them to pull the system log for case 14 PB-08834. Every filing has an electronic record, not just the paper stamp, but a server-side entry that logs the date, the time, and the user ID of whoever processed it. They called me back the next day. The system log showed one entry for the final order. September 22, 2014, 9:47 a.m. Processed by user TW. I asked for the full name attached to that user ID. There was a pause. The woman I was speaking with said she would need to check with records management. I never heard back. I called 3 more times over the following 2 weeks. No one could tell me who TW was. Multnomah County Clerk's Office employs roughly 40 people in the courthouse filing division. I know most of them by face. I asked Dennis Hargrove about TW directly. He said he didn't recognize the initials. He checked the staff directory going back 5 years. No TW in the filing division. Not currently, not in 2014, not in any employment record he could access. The person who stamped my order does not appear in any county employment roll. I turned back to the order itself. I had already found the language from paragraph 7b. The argument I made at 2:15 p.m., reproduced word for word in a document filed at 9:47 a.m. I went through the other 3 pages. On page 3, the order references a specific stipulation between counsel. During the hearing, the opposing attorney and I had agreed to a particular payment structure for the estate's brokerage account, a phased disbursement over 6 months rather than a single lump sum transfer. That agreement was negotiated in the courtroom, verbally, at approximately 3:05 p.m. We shook hands. The judge noted the stipulation in the record. It's in the transcript. Page 44, lines 8 through 19, and it's also in the order. Filed at 9:47 a.m., before the stipulation existed, before we had agreed to anything, before either of us had spoken a word. That's when I looked at the opposing attorney's name. I had been so focused on the timestamp that I hadn't examined the signature block carefully. On a court order, both attorneys of record sign. My signature is at the bottom left. The opposing attorney's signature is at the bottom right. The name printed beneath it, Deborah Ann Strickland. Oregon Bar number 190087. I stared at that name for a long time. I remembered Deborah Strickland. She was a well-regarded probate attorney in Portland. Sharp, professional. We had been on opposite sides of 2 or 3 cases over the years. I attended her memorial service, February 2011. She died of a sudden cardiac event. She was 54 years old. She died 3 years before case 14 PB-08834 was ever opened. I pulled her Oregon State Bar profile, bar number 190087, status inactive, date of inactivation March 15, 2011. Reason, death of licensee. That's the standard notation when a bar member dies. Her profile showed her admitted date, her 31 years of practice, and the inactive status taking effect a month after her death. She was not licensed to practice law on September 22, 2014. She had not been licensed to practice law since March 2011, but her name and bar number are on a court order filed in September 2014. Her signature is there. I checked the opposing attorney's formal appearance in the case record. Every attorney who appears in a probate matter files a notice, a document stating they represent a particular party and will be appearing on their behalf. In case 14 PB-08834, the notice of appearance for the other niece's attorney was filed on April 3, 2014. Attorney of record, Deborah Ann Strickland, Oregon Bar number 19-0087. filed April 3, 2014, more than 3 years after her death. I went back to Dennis Hargrove. I showed him the notice of appearance. I showed him her bar profile. He read both documents twice. He said, "I don't have an explanation for this." I asked if there was a supervising attorney, a law firm, anyone else associated with this appearance. He checked the full case record. No firm name, no associate, no co-counsel, just Deborah Ann Strickland, appearing alone in a probate dispute that opened 3 years after she died. I went looking for the other niece, the one Strickland had supposedly represented. Her name is listed in the case file as Miriam Voss Callahan. Portland address, 4419 Southeast Hawthorne Boulevard. I drove to that address. It's a vacant lot. It has been a vacant lot since 2009, according to city permit records. There's no structure there. There has never been a structure there, not in any period covered by the county assessor's records. I ran a check on Miriam Voss Callahan with the DMV. No record. I checked the Social Security Administration's Death Master file. No record of a Miriam Voss Callahan born in Oregon of any age. The opposing party in my case, the woman I argued against in that courtroom, does not appear in any database I could access. I went back to my billing records. I billed Caroline Voss Ardmore for 3.2 hours on September 22, 2014. That's a standard billing entry for a contested probate hearing. Travel time, preparation, the hearing itself, post-hearing notes. But the transcript is 47 minutes. Start time 2:15 p.m. The judge's closing statement appears on page 52. Court is adjourned 3:02 p.m. 47 minutes from start to finish. Even accounting for travel and preparation, 3.2 hours is a significant overcount for a 47-minute hearing. I checked my time log. I had written, September 22nd, Voss hearing, courthouse, full afternoon session. 3.2 hours, full afternoon session, a 47-minute hearing. I don't know what I thought I was doing for the other 2 hours. I don't have any notes from that afternoon beyond the transcript itself. My calendar shows the hearing. My parking receipt shows I left the garage at 4:30. That's nearly 3 hours after the hearing ended. I don't know where I was between 3:02 p.m. and 4:30 p.m. I have no record of those minutes. I went to my office and pulled the physical case file. I keep paper files, always have. Old habit from the days before everything was digital. The Voss file is 3 inches thick. I went through it page by page. Near the back, behind the signed copies of the final order, I found an exhibit I didn't remember including, a photograph, black and white, 8 by 10. It showed what appeared to be a courtroom, empty benches, a raised bench at the front, fluorescent lighting, stamped on the back in red ink, sealed. Exhibit D, Case Fort PB 8834. I have no memory of this photograph. I have no memory of any visual exhibit being submitted in this case. The case involved a will. The arguments were about written language. There is no reason for a photograph of an empty courtroom to be in this file. I turned it over several times. The room in the photograph does not look like the 4th floor of the Multnomah County Courthouse. The bench configuration is different. The windows are on the wrong side. I don't know where that photograph was taken. I don't know why it's in my file. I don't know who stamped it as an exhibit. By this point, I had been working through the file for 3 months. I had started with a timestamp that was 6 hours off, the kind of thing you figure out in a phone call. Now I had a dead attorney on the case record, a non-existent opposing party, a clerk who doesn't appear in any employment role, a photograph of an unknown courtroom sealed as an exhibit in a file I had believed I fully understood, and every attempt to explain one piece created a contradiction somewhere else. The dead attorney's appearance required someone to file paperwork in her name 3 years after she died. The non-existent opposing party required the court to accept pleadings from someone with no verifiable identity. The unverifiable clerk required a county employee who left no employment footprint. None of these things are small clerical errors. None of them have a single explanation that accounts for all of them at once. I kept looking anyway, because I still hadn't looked at my own bar record. And that is where it stopped being a paperwork problem. That is where it became something else entirely. Oregon State Bar maintains a record for every licensed attorney in the state. Admissions date, continuing education credits, any complaints, investigations, or disciplinary proceedings. I had checked my own file twice in 26 years. Once when I applied for a federal court appearance, once when I changed firms, both times clean. I pulled it a third time in January 2016. The file opened normally, admissions date, CLE credits, 2 malpractice inquiries, both closed without action, and then a third entry I had never seen before. Disciplinary notation. September 23, 2014, the day after the Voss hearing. The notation reads, attorney appeared in case 4PB-08834 without disclosing a potential conflict of interest under ORS 94603. Matter referred to Bar Conduct Review Panel 2014 CR07. Finding, dismissed without action. I read it twice. I had never been referred to a conduct review panel. I had never been contacted about a conflict of interest in the Voss case. I had never received a letter, a phone call, an email, or any communication from the Oregon State Bar in connection with Case 14 PB-08834. Not in 2014, not in 2015, not ever. But the notation is there. Filed September 23, 2014, dismissed. Someone processed a disciplinary action against me for a case I was in and resolved it, and I was never notified. I called the Oregon State Bar's Conduct Division. I gave them my bar number. I asked about the September 2014 notation. The man on the phone was polite. He said he would need to pull the physical record. He called me back the next afternoon. He said, the notation is in your file. The dismissal is also there. But the review panel listed on the dismissal document, panel 24-CR07, that number doesn't correspond to any review panel in our records from 2014. I asked him to check more carefully. He came back 20 minutes later. He said, I'm sorry, Mr. Caulfield. Panel 24-CR07 was not established until 2017. It's a rotating review panel. It didn't exist in 2014. A disciplinary action filed on September 23, 2014, dismissed by a review panel that was not created until 3 years later. I wrote that down. I dated my notes. I had started keeping everything dated because I was beginning to wonder what I would find next, and I wanted a record of the order in which I found it. I went further back. If my bar file contained a notation I didn't know about from 2014, I wanted to see everything. Every document, every entry, every cross-reference going back to my admissions date. I requested the full file. It took 3 weeks to arrive, 81 pages. Most of it I recognized. My admissions paperwork, annual certifications, the 2 malpractice inquiries. Then on page 63 I found a case reference I had never seen. Case OR 12P44-7, Multnomah County, filed 2009, an estate matter. My bar number appears in the case record as attorney of record for the petitioner. I have no memory of this case. I don't recognize the petitioner's name. I have no file for this case in my office. In 2009, I was 3 months into a new firm. My caseload that year is fully documented. I can account for every matter I handled from January through December. Case OR 12-PE4417 appears in none of those records. But my bar number is attached to it, and on page 64 of my bar file there is a signature under the case reference number. It looks like mine, The shape is right, the pressure pattern is right, the way I curved the C in Caulfield, but I did not sign it. I know I did not sign it, because the date on the signature line is March 3rd, 2009. And on March 3rd, 2009, I was in Seattle at a 2-day conference on estate tax reform. I have the registration record. I have the hotel receipt from the Westin. I have a photograph of myself at the conference dinner that evening. I was not in Portland on March 3rd, 2009, but my signature was. I hired a document examiner, not to prove anything in court. I had no case to bring. I hired her because I needed to understand what I was looking at. She reviewed both signatures, the one on the Voss final order and the one in the 2009 case file. She compared them against known samples from documents I had signed in her presence. Her conclusion: both signatures are consistent with my known handwriting. No evidence of tracing, no evidence of digital transfer or reproduction. These were not copies of my signature placed over documents. Someone produced signatures consistent with my hand in 2 separate cases on 2 dates when I can document being somewhere else. Or, and this is the possibility I keep coming back to, I signed both of them, and I have no memory of either moment. I went back to the Voss case one final time. I contacted the Multnomah County Assessor's Office and asked about the transfer of Martin Voss's house in the West Hills. If Caroline Voss Ardmore had received the estate as ordered, the house should have transferred into her name. Property transfers are simple public records. Every real property transaction in the county is logged with the assessor. I gave them the address, 2218 Southwest Custer Drive. The assessor's office responded within a week. The property is not transferred. Not in 2014, not in 2015, not in any year following Martin Voss's death. The current owner of record is Martin Ellery Voss, a man who died in January 2014. The estate was ruled on, the case was closed, the judgment is marked satisfied, and the house still belongs to the dead man. I tried to reach Caroline. The number I had on file for her in Bend was disconnected. I tried 2 other contact numbers from my file, both disconnected. No voicemail, no forwarding message. I asked a private investigator I occasionally work with to run a basic background search. He came back 3 days later. He said, "There is no Caroline Voss Ardmore in Oregon, not currently and not in 2014. No driver's license, no property records, no state tax filings, no utility accounts anywhere in the state." I asked if she might have moved. He said, "I checked nationally. There is no person by that name in any public database I can access. The woman who hired me, the woman I represented, the woman I won the case for, she does not appear to exist." The last thing I found by accident. I was going through the Oregon State Bar's archived quarterly bulletins. They publish a short newsletter each quarter with updates on bar membership, disciplinary summaries, and administrative notices. In the spring 2019 issue, on page 14, there is a notice. 3 sentences. Deborah Ann Strickland, Oregon Bar number 19-0087, has been reinstated to active status following a petition by her estate. Reinstated. Deborah Strickland died in February 2011. She was reinstated to active bar membership in May 2019. The notice does not explain how a deceased person petitions for reinstatement. It does not explain who filed the paperwork. It does not explain what the bar intends to do with an active license belonging to a dead attorney. It is just a notice. 3 sentences. And at the bottom of the entry in the contact field, the field where the bar lists a primary contact for correspondence, Case 14-PB08834. Not a name, not a phone number, not a firm address, a probate case number from 2014, a case with a judgment filed before the hearing, a non-existent opposing party, a non-existent client, a clerk no one can identify, a sealed photograph of a courtroom no one recognizes. That case is now the registered contact information for a bar license reactivated for a dead woman in 2019. I still have the original order, all 4 pages. The judge's signature, the clerk's stamp, the sealed photograph behind it, and at the bottom, my name. Raymond Caulfield, Oregon Bar number 472291. I don't know when I signed it. I don't know where I was when I signed it. I know the document was filed at 9:47 in the morning. I know the hearing began at 2:15 in the afternoon. I know everything the order contains was said in that courtroom. I said some of it myself. But the order came first. The hearing came second. The court ruled on my case before I had argued it. And everything I've found since then suggests that might have been the least impossible thing about it. I closed my practice in 2021. I don't work with case files anymore, but I keep the Voss order in my desk drawer. Not because I expect to find an explanation, because of what it says at the top. Filed September 22nd, 2014, 9:47 a.m. Before the hearing, before the arguments, before I walked into the courtroom, that document was there first.